bury or repress that awareness, that memory, in order to try and protect the person's mental health. And it may be something much later that triggers it and brings it back up again. So we'll see when those cases go to trial.
You know,
Sorry?
Do they have to prove that
That they were sexually assaulted?
from the time that they remember? Because like I know they're saying in the medical ones, you can prove it by when you go to the doctor and you see something wrong.
Right.
But
So
if it's mentally, like, do they need to prove that?
they do. They do. They would need a psychiatrist who's able to demonstrate that you can see from this person's mental history and from their behavioral history that they repress this awareness. They didn't talk about it with anybody, they didn't exhibit any signs of it, but something happened later to trigger that memory. Maybe they were abused again by a husband or a boyfriend or something like that, or maybe they saw in the news and that this has happened and it triggered the memory in their own experience. Yes, you do have to prove when that discovery happened.
By the way, what other jurisdictions are accepting those kinds of claims now? I mean, is it national?
Mm-hmm.
Yeah.
Right. Right. The discovery rule, and we're not talking about discovery about getting depositions and interrogatories and documents and stuff. The discovery rule about the time limit begins to run from the time that you discover the tort and the connection to the harm is national. That's a national common law rule. There are states in which some statutes have been passed that provide government bodies with more protection than others. So for example, in Hawaii, if a private person injures a minor, the time limit doesn't run until the minor turns 18. If the state injures a minor, it runs. The state has not given up sovereign immunity for what's called tolling or delay of the statute of limitations for minors. They get a different rule than everybody else. Does it make any sense? No, but they got it. So, okay. Animal cases, most of those are dog bite or dog attack cases. There is a statute here that basically says an owner is liable for an injury to person or property inflicted by an unleashed dog or animal. However, there's an intermediate court of appeals case that says, no, you still have to prove that the owner was negligent. So in a case that went to trial a few years ago, the older guy was out walking his little dog, and the bigger dog, no leash, got out and went after both of them and knocked the guy down and broke his shoulder, and he had surgery. And when he sued, the reason that he lost was that the owner came in and told the jury, oh no, we latched our gate very carefully when we left. Some mailman or some delivery person or some kid must have unlatched it and let the dog out. And the judge ruled, well, because you didn't prove that the owner was negligent. You didn't prove who left that gate open, so you lose. Even though the statute says an unleashed dog makes the owner liable, yeah, maybe yes, maybe no. The courts will change the statute rules if they feel like it. And my footnote comment on that is, if you want a cost-effective problem-solving mechanism in a legal dispute, the court is appropriately named the court of last resort. You don't want to be there. It's not cost-effective. The rules about the evidence that can come in and get to the jury are pretty antiquated and pretty limited. It's not like the jury gets to hear everything that's important or relevant, only things that meet the evidence rules. So for example, if the driver crashed into this person and they were drunk at the time and they told the lawyer, yep, I did, I crashed into him, I ran the red light, I was drunk. That's a privileged communication. If you can't find that out any other way, you can't use it. And maybe the guy comes into court and says, no, I had a beer, but I was fine, and I think he ran the stoplight. I think I had a green or maybe even yellow light. Happens all the time. I was up at the UH Law School a week or so ago, and there was this well-known ethics teacher was saying, lawyers don't lie to each other. And I'm looking at Sherry Broder, who's practiced here for years, and I'm looking at this. Well, there's the difference between academia and the real world. I don't think it would be fair to say that lawyers intentionally lie to each other in the way that we usually think of the word lying. What lawyers do, however, is they very selectively gather and present portions of the truth from selected perspectives. They want you to see that part of the truth they're presenting their way. Is that lying? As far as I'm concerned, yeah, right, it's not truth, so if you're going to black and white it, yes, it's lying, because you're coloring or slanting the truth. But that's our process. I mean, when clients come in to see me with a tort case, I'm going to tell them, if what you really want is to have 12, actually 14, because there's 2 alternate jurors. If you want to have 12 strangers who don't know anything about your case or situation, don't care about it, if it involves any kind of expertise, accident reconstruction, medical expertise, they're not going to understand that. If you want those 12 people to decide your case, given instructions by a political appointee who may be pretty good at their job or may not be very good at their job, we call those judges, and some are really good and some are not so good. Same as lawyers. There's lawyers too. Some are same as legislators. If that's your truth-seeking process, based on information that's provided by lawyers who are trying to slant that truth as heavily as they can to convince the jury to go their way, if that's your truth-seeking process, then maybe you should be looking for another lawyer. If, on the other hand, what you really want to do is to investigate and find out as accurately, as completely as possible, what the truth of the situation is, what the conduct of the parties was, who was negligent, if either one, who's legally responsible, what the harm and the damages are, and what fair compensation for that is, then fine, I'm happy to work with you. In our legal system, I think it's accurate to say that we do not have a level playing field in most cases. If you're in a medical malpractice case, the evidence rules and the economic power of the doctors in the hospital give them a huge advantage. It's very difficult for a plaintiff to win a medical malpractice case, and they usually don't. In auto accident cases, the advantages of the resources of the insurance company for the defense also make it not a level playing field. Fortunately, we have some great plaintiffs' attorneys, and they make it closer to a level playing field because they do a really good job. In dental malpractice cases, same as medical, same thing, very tilted playing field. Employment cases, very tilted in favor of the employer. Very difficult for an employee to win an employment discrimination case, a sexual harassment case, unless they have great evidence, really good. Some have been won. Dave Simons has done some great jobs on some cases, but most of them don't. I don't say that to criticize our legal system or to say that it's worse than any other. I just say it so that, hey, if you're going to work in this field, you won't go in with the expectation that going to court is going to bring a level playing field and a fair and a just result, or the truth. In my experience in 31 years, it's just as likely not to do that as it is to do that. So that's why I mediate and arbitrate, because it gives the parties a chance to select someone who is much more experienced in the area where their dispute arises, whether it's an auto accident or a real estate dispute or an IT dispute or an employment dispute. It gives them the chance to choose somebody whose neutrality, impartiality, knowledge, and experience is respected by both sides, because that's the only way they're going to agree. If both sides agree this person is knowledgeable and fair, the chance of getting, to me, the chance of getting a more fair and just result, much less expensively and much more confidential outside of court, is much greater in that setting. So I heavily favor mediation and arbitration. I also favor mediation because it's the party's last chance to have a voice in what the result is. If you want to have a vote or a say in what that settlement or that agreement are, once mediation is gone and you're in arbitration or you're in trial, a stranger is going to decide. You've given up that control. You've given up that vote. And it may not be what you like. Or you may win, but it may cost you so much that your net may be less than you could have gotten by settling earlier. And that's why in Hawaii, about 98% of federal cases settle without going through trial, and around 93 to 95% of the state cases settle without going through trial. It's not because mediation's so great. Most of them settle and negotiate. Okay. Products liability, if you're injured by a product, there is strict liability. If you can prove that the product was defective and dangerous and that it caused harm, you win. You don't have to prove that the design was negligent. You don't have to prove that the construction of the product was negligent. If you prove that it was defective and it was dangerous and it caused harm, you're home free, strict liability. So in that Pinto gas tank case, once they showed what the defect in the Pinto design was, they didn't have to show it was negligent. They just had to show it was defective and dangerous. They win. And the tobacco cases, the reason that the tobacco cases that went against the tobacco cases, companies won, was because they knew it was harmful and they put it out there without adequate warnings. The only warning was Surgeon General says, this is probably harmful to your health. There were whole bunches of stuff that they knew that they didn't